Professor Jagadish K. Patnaik, Vice Chancellor, and today's chief guest. Dignitaries, Sri Yananthan, Registrar in Charge and Controller. Today's resource person in physical mode, Dr. Rumi Dar, Assistant Professor, Department of Law, Nagaland University. And in online mode, lecturer, resource person, Professor Subram Raj Kowa, Professor USTM, Meghalaya, former Dean and Head, PG Department of Law, Bharati University. Officers, faculty, and all university fraternity gathered here today. A very warm welcome to this lecture program on a very auspicious occasion of the coming into force of 3 new criminal laws, which will be explained to us by the 2 resource persons. Today's program, we will have the lectures followed by question and answers. So those present here as well as those joining us online are very much welcome to ask questions, clarify doubts about these 3 new laws. That will be followed by a special address by our chief guest. And the vote of thanks will be delivered by Mr. Ashish Kumar, the officer and AR in charge to Vice Chancellor. So without much ado, let us commence with the program. Now may I request Susmita to please hand over a token of appreciation to our chief guest as well as dignitaries. Sir, a small token. Now we also request Yanan sir to receive a small token. Also a small token for our resource person who is present in physical mode, Dr. Rumi Dar. Thank you. For our resource person in physical mode, unfortunately, we'll have to make another presentation. Thank you. Now we shall start with the first lecture from Dr. Rumi Dar.
Namaskar to all. Honorable Vice Chancellor Sir, Professor Jagadish Kumar Patnaik, respected Registrar in Charge and COE Sir, Mr. Yananthan Izan, respected Professor S. Rajkowar Sir, respected Chairperson of today's program, Mr. Peter Ki, respected Ashish Ji, Committee Member of today's program, all the officers, directors, deans, heads, teaching and non-teaching staffs of Nagaland University, all the dignitaries who are in online mode, and dear research scholars. Today is a very remarkable day for the Indian judicial system. First of all, I would like to congratulate all for the new reenactment of these 3 new laws. Today, I am in front of you to discuss these revolutionary changes in Indian law history, where after 160 years of old act has been replaced. And this will be effective from today. So from today, all this will be facing new changes. So today, I am just trying to bring a small awareness session for all of you. The Indian Penal Code, the Criminal Procedure Code and the Indian Evidence Act come in the category of major laws in Indian judicial system. The Indian Penal Code, as we know, that functions as the substantive law delineating the rights and obligations of citizens. Code of Criminal Procedure, which continues or which outlines the procedures by which these substantive laws are to be enforced. And the Indian Evidence Act plays a crucial role in specifying the admissibility of statements in court and the presentation of evidence. So actually the government introduction of these laws stem from the observation that the existing laws were inadequate to address the technological advancements and societal shifts that have occurred over past few decades. So in 2020, the Ministry of Home Affairs constituted a committee which was headed by Dr. Ranveer Singh. The committee's focus was to ensure the security and safety of communities, individuals and the nation. During all the discussions and meetings, the committee's aim was to uphold constitutional values such as justice, dignity and the intrinsic value of everyone. So the bill obtained the President's assent on 25th December 2023 and will be recognized as acts. And then these acts then introduced by the central governments are Bharatiya Nyaya Sanhita, second act herein referred to as BNS Act, Bharatiya Sakshya, second act herein referred to as BS Act, and Bharatiya Nagrik Suraksha Sanhita, second act, and here is referred to as BNS Act, BNSS Act. So this act actually repeals the British era Indian Penal Code, the Code of Criminal Procedure and the Indian Evidence Act respectively. Next slide. Now the question maybe come to our mind that why we need for these new acts. There is some purpose. So the purpose of the reenactment is to revamp the Indian criminal justice system by replacing colonial era laws. The reenacted laws are started to be victim-centric and more suitable for the new technological era. They are also stated to be better suited for the present requirements of society. Today's society's demand, the requirement, national security and introducing digital or you can say the electronic atmosphere or evidence reviews and making them priorities of these laws. So, our Honorable Prime Minister, Shri Narendra Modi ji, also in the month of January underscored that these new criminal laws were crafted with the principles of citizen first, dignity first and justice first. So he emphasized a shift from relying on force to data, urging that the police to work with information and technology for effective law enforcement. Even our Honorable Chief Justice of India, D.Y. Chandrachud sir, hailed the enactment of these three new criminal laws and called it as a watershed moment. He also, they said that these new laws are a clear indication of a changing India. India is on a move and we do need legal instruments to deal with the current challenges that we envisage for the future of our society. Then next we come to our key features, that is number one, Bharatiya Nyaya Sanhita, BNS Act, which repeals IPC. The penal sections of law actually mostly relate to the cases of cheating, criminal misappropriation, breach of trust, forgery or use of forged documents. But these sections actually providing for the definitions of these offences only largely and it can remain unchanged. But now this act, that is Bharatiya Nyaya Sanhita Act, changes the significant amendments in the legislation and this section 69, 109, 111 and others like the death penalty provisions is introduced for crimes against girls below 18 years of age. Like for example rape and sexual assault. Provisions on sexual assault on women below 18 have been aligned with the POCSO Act to prevent the accused from taking advantages of the lenient provisions of the penal code. For minors rape, lifelong imprisonment or death penalty has been mandated. And in case of gang rape, 20 years of imprisonment or binding or lifelong imprisonment has been mandated. So it means that additionally, the laws have been made gender neutral by including the trade of minor boys as a crime also. Next comes, that is our Bharatiya Nagrik Suraksha Sanhita, BNSS repeal, which repeals CRPC, which repeals Criminal Procedure Code, which defines the additional types of electronic devices, empowers courts and police officers to issue summons in cases where digital evidence is involved, clarifies the jurisdictions in cheating cases which involving electronic modes of deception, like empowers courts to ask for electronic filings in cases where documents are voluminous. It means that the significant amendments of this act is also give emphasis upon the society, upon the community, where electronic mode is permitted for all trials, inquiries and proceedings under section 173 of the BNSS Act. and if the proclaimed offender or avoids trial by absconding, the judgment can be pronounced in their absence also. This is the new act. Like if someone is not in the offense has been committed in India and the person is in outside of India, then also this offense has been tried in Indian courts after the 90 days of time limit. Then this earlier CRPC actually permitted medical examination including rape cases conducted by a registered medical practitioner upon request of a sub-inspector. But now this BNSS Act expands this by allowing any police officer to make such a request to the medical officer. So the concept of again the zero FIR is also introduced under section 173 and mandates police stations to register the FIR regardless of jurisdiction. Zero FIR means that FIR is registered irrespective of the area where the offense is committed. So this act has included this zero FIR provision also. Thank you to all.
So I think that sets the stage for our next resource person, Professor Subram Rajkova. Thank you for accepting our short notice invitation.
A very good afternoon, the Honorable Vice Chancellor and all the dignitaries present. So today is a very important occasion because it's a watershed development in the criminal law jurisprudence of the country. As we all know, from this day, the three criminal major acts, namely the Indian Penal Code, the Code of Criminal Procedure, and the Indian Evidence Act, which have been repealed, and the three new laws, namely BNSS, Saksha Awin, has come into force. So from this day, all cases which will come up before the courts on all FIRs and other matters related to criminal law will be governed by the new set of laws. There have been certain worries with regard to the nature of the implementation of the set of laws, and it is in that aspect, or it is in that context, that the government has made elaborate arrangements across the country to hold series of meetings, awareness programs, so as to enlighten or bring about awareness amongst the public as to what are the changes that have been effected. The magistrate is giving certain discretion, or the judicial officer is giving certain discretion. So the fine may be within the discretion that is set by the law, not beyond. Say, for example, if you take the case of last year, when a prominent opposition leader was held guilty by a court and a sentence was imposed of 2 years. Now, that is subject to challenge, but then the thing is, that was the maximum that was permissible under the law, and that was being awarded. Now, if the higher judiciary feels otherwise, then they may decide accordingly. Here also, when you speak of sentence, it does not say sentence for 1 year, 2 years like that, but it says sentence up to 6 months, up to 1 year. But then in certain stringent cases, it says the minimum sentence is 5 years, or 7 years, or 3 years. So in such cases, it has been fixed that the judicial officer does not have any liberty. So to respond to your query, what was earlier restricted is not so at present. Presently, in certain cases, it has been laid down specifically under the particular provision as the nature of the sentence, as the nature of fine and sentence to be imposed. The term of fine, the term of imprisonment, as well as the of fine. Thank you.
Thank you, sir. Any more questions?
Yeah, I have one query. Is there any transitional provision for implementation of the new acts? If not, what will be the status of the cases or FIRs that have been filed under the repealed or amended or deleted laws? Thank you.
Yes, this is a very pertinent question and which has been taken care of by the law. So here, if we look at the Act has been very clear on one important issue, and that is provided under section 358. So when we speak of repeal, repeal means the old law is gone, or the law is gone and there is no law for that particular purpose. Say for example, in this particular region, particularly with regard to assent. Now, once the Supreme Court made these observations in Sarbanan Sanwal's case, the government had to repeal the Act. So, that was not replaced by any new law. It was totally repealed. It was gone entirely. Now here, there are two important provisions. One, the Act is repealed. What happens to those cases which are pending before a court of law? And what happens to a situation where a person is not aware of the change in the law? So far, the lack of awareness, the law says that ignorance of law is no excuse. And therefore, one cannot take the plea that I did not see that, I was abroad, I was not aware, I was in hospital. These things will not work because law is presumed to be known by all and one has to abide by it. It is easier said than done. But then what happens to situations? I'll cover two situations. One is 358 and before that I'll take up another case. Say for example, last night at 11:59, a murder took place. Now, it was 1 minute before the lapse of this particular act. Now that situation has to be dealt with under the old law and not by the new law. Now, how do you deal with it under the old law? Whether in such a situation or in cases where matters are pending for years together. In such cases, what we have is that we have section 358, which is very clear. It says, notwithstanding such repeal, anything done or any action taken under the said code, that is the Code of Criminal Procedure, IPC, shall be deemed to have been done or taken under the corresponding provisions of the Sanhita. So if the changes are simply some section has been replaced or some section has been brought to renamed by another section, in that case the same will continue. But then if it is provided that mention of particular matters shall not be held to prejudice or affect the application of Section 6 of the General Clauses Act. So here it says that despite the repeal of old provisions, old cases, all pending cases will be dealt with by the old law. So this is a saving clause, and therefore it says, Section 358 says repeal and savings. Although the Act has been repealed, the saving clause is there, which says that for the purpose of the pending cases, the old law will continue to prevail and all matters will be dealt with accordingly. And there's a very old act passed by the Britishers, which was passed in the year 1897, which is known as the General Clauses Act. And it says, it draws a reference to the application of General Clauses Act, Section 6 of the General Clauses Act, in conjunction with the saving provisions under Section 358, all pending matters will be dealt with under the old law. Thank you.
PRO, in charge of the registrar, honorable resource persons, and my dear colleagues. This has been really an enlightening exercise. It's not only regarding the making us aware of the latest legal framework that is coming to place with effect from today. But it also enables us to know, at least for myself, I can speak for myself, that I got really enlightened and got such a useful exposure from both the resource persons. Since the last 10 years, we have seen so many changes taking place in our political system. And these changes are not only just mere changes, but transformative, and has brought in a lot of developments. To top it all, as you are all aware of the fact that the economic transformation has made us so bold enough to assert ourselves in the Committee of Nations, while our internal social, cultural ecosystem has also moved in keeping pace with the changes taking place in the world. Why I am telling this is because the colonial hangover, the baggages that we have had since the independence, that is the last 75, 76 years, we still continue. And particularly with regard to the legal framework and the legal system as such, this colonial hangover has to be removed, lock, stock and barrel. Because of the legal weapon, the colonialists wanted to subjugate us. These are the instruments that they exercised to penalize, to criminalize, to make us subservient to their objectives and goals. And these things we could not realize. We took 75 years, unfortunately, to throw out wholly the legal structure that they had put up. Such kind of mechanisms are really important for us in terms of running the state. As you all are aware of the fact that the 21st century challenges are different from the 19th century challenges and 20th century challenges. In the 21st century, we saw the emergence of new phenomena. There is the concept of terrorism. Terrorism was old, but the modus operandi of the terrorists has changed so much that it is very difficult to bring him under the sedition law. The age-old sedition law is just meant for preventing the freedom of the individual and the citizens. And if you raise anything against the state, then you will be put under sedition law 124. And that has been thrown. And it has been replaced with the new law, which would handle with the issues such as separatism. The unity and integrity of the country is very important. And the state to survive and develop and grow, we need to have the unity and integrity of the nation. And the separatist tendencies that actually eats into the vitals of the state that nobody understands. If you are a responsible citizen, these separatist ideas and tendencies, they damage to a great extent not only the identity of the nation state or the civilization state. Because I am still, having some doubts about India identifying itself as a nation state. No, we are all nations. Different nations are there, different, and we're part of the civilization. And this framework is there. That I've been telling my pet theme. What I mean to say is, alongside that, the technological developments. You see, you have got ICT. In ICT, you have got cyber crimes. And it's very notorious. You will not believe a small, not only mobile, a small watch somebody has gifted to you, and you put in your office or in a home, and it would send messages to China. Believe me, many of the Chinese gadgets that we have, they are so much fabricated in such a way that many things, even if you cough what kind of cough we have. That kind of thing is being, reported there. We don't know. Of course, we can't do China boycott thing because our economy is dependent heavily on China. And this issue, how to handle it? I'll tell you a very interesting thing. I was reading about this, not now, but I have been reading, everybody is reading, so I was reading. Very interesting thing I'll tell you. Supposing you lend some money to you somebody, XYZ, out of good faith. I'm talking about my personal experience. And what happens? You ask that man to return the money. Once, twice, thrice. And you ask through your WhatsApp. And then he will be responding, I will give you, I will not give you, I will not give you. Something he will be responding. Do you know this? Now because of this Nyaya Sanhita, that's Evidence Act, Bharatiya Nyaya Sanhita. Nyaya Sanhita, not Nyaya. The Nyaya Sanhita, Evidence Act. That piece of evidence in the WhatsApp is going to be recognized and accepted for filing an FIR. This is the most wonderful kind of thing that this government has undertaken. This is only one example I am citing. There are numerous cases which this honorable resource person Raj Khuaji has mentioned and also we mentioned. So there is a need to look into these new developments. And there is, of course, this transition is there, and there will be the baggage will be continuing for a while. And for that, we need our legal officials, our advocates, everybody need to be more smart to bring this law into force rather than clinging on to the old system, because there is a possibility of getting it sabotaged. Remember this. I am worried about that. Because those cases that are pending still may continue for years together. Because there is no deadline. Whereas in the case, in this new legal system, you have got some deadline in dealing with the different sections. So that is the uniqueness of the thing. And of course, as and when we evolve, and when there will be different kinds of situations that will emerge, obviously new sections may be incorporated and those can be amended. But the fact of the matter is, there is a total transformation in the legal ecosystem is we have to accept. And we should be really, really thankful to the government that they have come up with this new set of rules. And I think the citizens will be definitely benefiting out of this. I actually am very, very happy that the law department, along with our other officials, have been able to organize this wonderful seminar. And also I am thankful to both the research persons for having come up prepared, including Rumiji. She has come prepared and she did have slides, everything. It's not a big deal, but it is definitely a big deal. Not a big deal, but a big deal from Rumi's point of view. So wonderful. I thank both the resource persons, and I am looking forward to further discussions and much more engaging sessions like this in future, so that we can get ourselves acquainted with the new provisions of the law. Thank you very much. Thanks a lot.
Thank you, sir, for contextualizing this whole program. Now I request Mr. Ashish to take the floor, please. Good afternoon, everyone. First of all, I would like to thank our Honorable Vice Chancellor, sir, Professor J.K. Patnaik. Since beginning of this, all the concepts, the 3 new criminal laws, he was aware, he was continuously monitoring what kind of programs, what kind of meetings that we are having to conduct this program, or sir, in future also we are organizing some more programs in relation with these 3 new criminal laws. Thanks a lot, sir, to be with us in this program. I would like to thank both the resource persons. First of all, I would like to thank Professor Subramanian Rajkhova, sir, who is Professor USTM Meghalaya and former Dean and Head PG Department of Law, Guwahati University. Sir, you have highlighted all the key points related with these 3 new laws, Sanhitas. and I will request you in future also, you will give your time because our audience is much happy and to find you here in our program. I would like to thank Ma'am Rumi, and she is our organizing committee member also. She has presented a wonderful PowerPoint presentation. Thank you so much, ma'am. Now, thanks to each and everyone, all the heads, deans, officers, faculties, those who are present physically or those who are present through online mode. I am watching our Pro Vice Chancellor, Sir, Professor G.T. Thong, sir, is also available. Head Department of English, Professor Das, sir, is also available. Dean, School of Social Sciences, Professor M.K. Sinha, sir, is also here. I would like to thank each and everyone to be the part of this important program. I would like to thank all the staff members of Lumami campus, those who are present here. Thanks a lot. I would like to thank our PRO sir. He is the chairman of this organizing committee also.